What do you make of the argument that in actual practice, the affirmation in the midst of this civic exercise as a religious affirmation is so tepid, so diluted, then so far, let's say, from a compulsory prayer, that in fact it should be, in effect, beneath the constitutional radar. It's sometimes, you know the phrase, the Rostow phrase, the ceremonial deism. What do you make of that argument, even assuming that, as I do, that there is some affirmation involved when the child says this as a technical matter?
I think that whole concept goes completely against the ideals underlying the Establishment Clause. We saw in Minersville v. Gobitis and West Virginia v. Barnett something that most people don't consider to be religious at all, to be of essential religious value to those Jehovah's Witnesses who objected. And for the government to come in and say, we've decided for you this is inconsequential or unimportant, is an arrogant pretension, said James Madison. He said in his memorial and
Well, I think the argument is not that the government is saying we are defining this as inconsequential for you. I think the argument is that simply the way we live and think and work in schools and in civic society in which the pledge is made, that whatever is distinctively religious as an affirmation is simply lost. It's not that the government is saying you've got to pretend that it's lost. The argument is that it is lost, that the religious as distinct from a civic content is close to disappearing here.
And again, I don't mean to go back, but it seems to me that is a view that you may choose to take and the majority of Americans may choose to take. But it's not the view I take. And when I see the flag and I think of pledging allegiance, it's like I'm getting slapped in the face every time. Bam, you know, this is a nation under God. Your religious belief system is wrong. And here I want to be able to tell my child that I have a very valid religious belief system. Go to church with your mother, go see Buddhists, do anything you want. I love the idea that she's being exposed to other things. But I want my religious belief system to be given the same weight as everybody else's. And the government comes in here and says, no, Newdow, your religious belief system is wrong, and the mother's is right, and anyone else who believes in God is right. And
if you had her in this courtroom and she stood up when the justices entered and she heard the words, God save the United States and this honorable court, wouldn't the injury that you're complaining about be exactly the same? So you would have equal standing on your account of things to challenge that as you do to challenge what the school district does here?
I don't think the injury would be even close to the same. She's not being asked to stand up, place her hand on her heart, and say, I affirm this belief. And I think that can easily distinguish this case from all those other situations. Here she is being asked to stand and say that there exists a God. The government can't ever impose that.
If she's asked to repeat or to sing, as the Chief Justice suggested, God bless America, then she is speaking those words.
Again, if it were a situation where we said, let's only do nothing else in this classroom, right? We'll say, God bless America, and let's just say those words or something, I think that would violate the Constitution as well. If it's just, let's sing one song a day and once a month we get God bless America, no, that would be certainly fine. We don't want to be hostile to religion. But here it's not a question of being hostile to religion. It's indoctrinating children, and Congress said that was the purpose. This Court is supposed to give credence and
you think of that, God bless America, as religion is not exactly like a hymn that you'd sing in church.
No, and again, if it were used for the purpose to say that there exists a God, then I think it would violate the Constitution. If it's merely a song, and this is one of many songs, then it would be fine. But here, there's nothing else in the Pledge of Allegiance. There's no other view here. There's one view being enunciated. That is that there exists a God. And government may not take a view. This Court is every justice here.
Well, I don't know. I mean, that's the point. I have no doubt that it offends you, and I respect the fact that you're right to be offended. I understand that. But the question is whether Congress, whether the government has the power to work that kind of offense. And on that, because you say, well, it doesn't have the right. Well, why doesn't it have the right? It isn't that divisive if, in fact, you have a very broad understanding of God. It's not a prayer. It's in a ceremonial context, and it has a long history of being evoked for civic purposes. Of course, some people will be offended, but those people who are offended can, in fact, ask the child, where they have custody, to be excused or not to say the words "under God." So it's not perfect. It's not perfect. But it serves a purpose of unification at the price of offending a small number of people like you. So tell me from ground one why the country cannot do that.
Well, first of all, for 62 years, this pledge did serve the purpose of unification, and it did do it perfectly. It didn't include some religious dogma that separated out some. And I don't think there's anything in the Constitution that says what percentage of people get separated out. Additionally, again, we can use that example that I raised before with one nation under Jesus. That would also separate out just a few people relatively in our country. There's not that many more. It's about 86% to 93%, somewhere in that vicinity. So we're separating out another amount of people. But again, the principle is the same. We are separating out people. We don't need to. Again, the Pledge of Allegiance did absolutely fine and got us through 2 world wars, got us through the Depression, got us through everything without God. And Congress stuck God in there for that particular reason. And the idea that it's not divisive, I think, is somewhat, shown to be questionable, at least, by what happened in the result of the Ninth Circuit's opinion. The country went berserk because people were so upset that God was going to be taken out of the Pledge of Allegiance.
Do we know what the vote was in Congress apropos of divisiveness to adopt the "under God" phrase?
In 1954?
Yes.
It was apparently unanimous. There was no objection. There's no challenge.
Well, that doesn't sound divisive.
It doesn't sound divisive. That's only because no atheist can get elected to public office. The studies show that 48% of the population cannot get elected.
The courtroom will be cleared if there's any more clapping. Proceed, Mr.
There are right now in 8 states in their constitutions provisions that say things like South Carolina's Constitution, no person who denies the existence of a supreme being shall hold any office under this Constitution. Among those 8 states, there's 1,328, I believe, the number of legislators, not one of which has tried to get those phrases out of their state constitutions, because they know, should they do that, they'll never get reelected, because nobody likes somebody to stand up for atheists. And that's one of the key problems.